tell everybody out there what the history of the Gadsden flag is.
Oh yeah, just don't tread on me. It's an old principle from the American Revolution. In fact, somebody took your anniversary photo and I think memed "Don't tread on me" flag in between. So it's you and Marion with a "Don't tread on me" flag front. So yeah, I mean, it was another ludicrous interpretation by another lunatic school, and credit to the kid for standing up for what's right.
It's fantastic. All right, that was the white pill, I guess. We'll do.
Well, I mean, we can do the most popular question on our board today is the big win that came down maybe on Friday, actually, against the Food and Drug Administration concerning ivermectin, but its impact is much broader than that.
Let me pull up the link just so we can highlight the conclusion, because it's a great conclusion. Who was the plaintiff in this?
Several doctors. Dr. Bowd was one of them. Dr. Meritz, I think, was another one. A bunch of doctors basically brought the challenge.
And so we'll just read the conclusion, and then, Robert, you'll explain why it obviously has broader impact than just this decision. They were suing for declaratory judgment, among other things. It says the conclusion. This is just a summary of the entire case. FDA is not a physician. It has authority to inform, announce, and apprise, the trilogy. Not endorse, denounce, or advise. It's beautiful. The doctors have plausibly alleged that FDA's posts fell on the wrong side of the line between telling about and telling to. Y'all remember, you're not a horse. Don't take the horse pace. Stop it, y'all. I mean, then they have to talk in a vernacular like they think they're talking down to people who are incapable of understanding. As such, the doctors can use the APA to assert their ultraviolet virus claims against the agencies and the officials. Even tweet-sized doses of personalized medical advice are beyond FDA's statutory authority. Robert, you might want to get into the ultravirus claim that it's beyond the scope of the FDA's authority. Maybe flesh that out for people.
So yeah, the district court had denied any right to sue on the grounds that they were not within the protected interest and that they couldn't sue, and sovereign immunity applied. They still have to get to standing on remand, but the logic that the court applies would say they would have standing as well, since, as the court itself acknowledges, there's an overlap with that and whether or not you fit within in the sovereign immunity analysis. So, generally speaking, you can't sue the federal government. I've disagreed with this from its inception. The doctrine of sovereign immunity derives from the idea that the king, as representative of God, can do no wrong. That's abhorrent to the American Constitution and to the American sense of liberty and the Declaration of Independence and common sense and the "don't tread on me" principle and precept, necessarily so. But the courts invented it, and then the politicians embraced it to be able to pretend that they're God when they act. So that's my first problem with all of this sovereign immunity garbage. But putting that aside, there is still an exception to sovereign immunity under both federal common law and under the Administrative Procedures Act, as amended in 1976, which provides that if a government official or agency is acting outside of its authority, and the way to think of this, and this will be a recurring thing tonight in some range of contexts, is a lot of its agency principles. For those lawyers that remember biz orgs, that I think that was my highest grade actually in law school, even though that was another class I don't think I ever attended. I'm not even sure who taught that class. But I showed up for the exam, and that was another one where I filled out the teacher grade. Everybody laughed because I'd never been there, but good teacher. When is somebody acting on within their authority, like your employee, or if you're an employee, the same kind of principles here. In other words, they're clothed in the power of the state. When are they in fact clothed in the power of the state, and when are they not? And the issue is that if there's a specific law that says you can't do A, B, C, or D, then you're clearly not clothed in the power of the state when you act. And so consequently, under the federal common law, they've acknowledged that you can bring a suit for declaratory or injunctive reasons, or even against them individually, because they're not acting in their sovereign capacity. They're no longer clothed with state authority. They were doing so on a personal, individual basis because they weren't given to it. The Administrative Procedures Act went further, and they call it a non-statutory cause of action, which can be confusing to people because it's a statute that's being cited for the non-statutory cause of action. But what they mean by that is whenever you're suing because the person acted outside their authority, the Administrative Procedures Act gives you a right to sue on those grounds, independent of the rest of the Administrative Procedures Act. So all you have to show is that the agency took an action, and that action specifically adversely impacted you, and that the action that they took was either specifically denied them or without any color of authority for them to legally do. And here, the FDA has been for a long time, for people that don't know, the Food and and Drug Administration, like to some degree the U.S. Department of Agriculture, but especially the Food and Drug Administration, was originally those laws were passed simply to make sure there was accuracy in marketing. They were not supposed to be the world's doctor. That was not supposed to happen. Some people warned that would happen, but that was not what the law provided for. That wasn't the public policy or rationale behind it. To make that clear, in the law itself, it says the FDA nothing in the law shall be used for the FDA to interfere with a provider's right, a healthcare provider's right to prescribe something legally to a patient. So they made clear that the doctors provide medicine, the states regulate medicine, not the federal government. Federal government is in the accuracy and marketing business, as the court noted, to provide data and information, not provide medical advice. So the doctors sued saying, look, the FDA is no longer providing information. They're providing opinions with imperative recommendations that override and are endangering actual medical advice by actual doctors to real patients, to such a degree that medical boards and credentialing agencies were using it to go after these doctors, as well as them being subject to smear and censorship campaigns and being subject to being terminated and fired by various people, including insurance providers or hospitals or universities where they may be employed. And so they brought suit saying the FDA has no business doing this. And so the district court sued saying everybody's immune. Fifth Circuit Court of Appeals came in and unanimously ruled, no, they're not. And they famously started off the opinion with the FDA's advice saying you're not a horse.
I'll bring it up because people have to understand it was not just saying, it was not information. It was, this is instruction. You are not a horse. You are not a cow. Seriously, y'all, stop it. Thank you for taking the job of every private doctor and with their patient out there, FDA, for telling people what to do. So they came to the conclusion this was not just a mere statement of fact or whatever. It was instruction, advice.
Exactly. And they said the law is clear. The FDA has no such authority. Congress took it away from them, especially as it impacts the patient-provider relationship. And what they ultimately and repeatedly said, the FDA cannot endorse, denounce, advise on medical care. They cannot, quote, give personalized medical advice. All of that is beyond their authority. And anybody that does so can now be sued without risk of sovereign immunity if they've been specifically adversely impacted by it. That's where the significance of this opinion goes way past ivermectin, because the FDA has been doing this in a lot of contexts, including the COVID vaccine context. So we brought suit with an appeal currently pending on behalf of Children's Health Defense against the FDA before this same Fifth Circuit Court of Appeals. And the issue was the FDA lying to parents to try to get their kids vaccinated against what was in the interest of what honest and accurate information would have provided. So to me, and one of the grounds the district court dismissed was sovereign immunity. So in my view, that those grounds should be clearly reversed. He also dismissed on grounds of standing. The same logic would apply. That should be clearly reversed. So not only does it impact that case, but it impacts other cases that we are looking at with Children's Health Defense, because a lot of state officials, a lot of federal officials have been out there lying to people. We're looking at behalf of people who've been injured or died from the vaccine, also looking to potentially sue everybody who lied about this. Not only suing Dr. Fauci, who lied about this, got caught lying by CNN of all people this past weekend about all the mask lies he'd been telling. But for example, every single one of those late night hosts went out and gave false information to people about the vaccine. I don't know why they can't be sued. All those people cheerleading those Alex Jones suits that radically expanded the law of liability for statements you make. Okay, let's time for what's good for the goose to be good for the gander. And so we're looking at suing everybody who went out and lied about the vaccine, its safety, lied about its efficacy, lied about ivermectin. Why did that matter? Well, Pfizer went berserk. Pfizer's lawyers went berserk when we pointed out in the amended complaint that ivermectin was in fact an effective alternative, and had Pfizer acknowledged or admitted that, then Pfizer never would have got any authorization for the vaccine and the billions of dollars they stuck in their pocket. And so they went nuts saying, how dare you suggest ivermectin can be effective? Why? Because it was effective, as has now been admitted by more and more authorities, and was clear at the time to a wide range of well-recognized and well-regarded and well-respected doctors. So to me, anybody who lied about ivermectin can be potentially liable, because even though there's legal immunity for the drug companies from the injuries caused by the vaccine, it's not clear everybody else is immune.
I brought up the tweet, or this was the article. FDA says telling people not to take ivermectin for COVID-19 was just a recommendation. Even if you buy that, which is bullshit, it's a recommendation that they had no statutory authority to make in the first place. And so the idea here, Robert, is it's ultra-virus their statutory authority, therefore they don't get to claim sovereign immunity or qualify. Which was, what is it?
Yep.
Sovereign or
yeah,
qualified?
Sovereign immunity.
Okay.
And ultra-virus, for those people who wonder, it just means without authority. You did something without authority.
When you first sent that to me, I appreciate exactly what you're talking about here in terms of other medical advice that they might have given as relates to other drugs. I immediately thought, yes, going after Rachel Maddow for begging people to go get vaccinated. If you've been hesitant, just do it. But then I was also thinking like YouTube censorship, taking down videos that contained medical advice. I guess the idea here is it wouldn't apply because they're not a government body, so the APA wouldn't apply. But does this open the door for broader civil actions potentially? Because the idea here is if the FDA couldn't give medical recommendations because it was beyond their authority, surely non-government agencies or non-medical professionals ought never have done the same thing.
All these people pretending to be doctors saying that there was medical advice. I mean, the conclusion was the FDA had no authority to act as a doctor, well, nor did any of these other people. And they don't have sovereign immunity to begin with. So it's looking at who can its legal remedy be sought about for participating in a censorship campaign, for participating in a propaganda campaign that led to the injury and death of millions of people around the world.
All right. Are there recourse? I mean, what is there recourse? The government's going to take it the next step on appeal? Could they?
That would be the U.S. Supreme Court. I find that ill-advised by them.
May I ask why?
Because all that could likely happen is they lose worse.
And now one other question that I have to ask. We talked about it at the time. In order to get the emergency use authorization for the jibby jab, there had to have been no existing remedy or no existing methods for treatment. Someone had recently, I forget where it came from, said that that was false. That was wrong. RFK is wrong for having said it, and that it's not factually correct. And then I know who I trust, but can you add to that or clarify that? Is it in fact the case that they would not have gotten emergency use authorization if there had existed other alternative remedies?
That's indisputable. Anybody saying otherwise can't read a law.
Okay, good. Just end it. The people, they plant a seed of doubt in my own spirit, Robert, and then I don't know what to believe anymore.